Hello, my dear students. Welcome you all in the Civics class. Today we are going to start a new chapter, chapter number 3 of Civics section, that is parliamentary form of government or parliamentary government. So, as Indians, we all are proud of the fact that our country is a democracy. In this chapter, we will get to know about some functions of our Indian parliament. It also discussed the idea of parliamentary democracy. One will get to understand the relation between the ideas of individual participating in the process of decision making and the democratic government's need to have the consent of the country's citizen. As we all know, our country became independent on August 15th, 1947. It was preceded by a struggle over a long period of time in which people from all sections of societies had participated. The people who had joined the freedom struggle were inspired by the ideas related to equality, freedom, and participation in the process of decision making. These people did not approve of the ways through which the British were ruling our country. During the British regime, whenever the people of India tried to protest against India, they faced grave danger in the form of severe punishment. After the freedom movement started, the situation started changing on a small scale. The Indian nationalists started criticizing the British government and making demands. It was in 1885 when the newly formed Indian National Congress placed a demand in front of British government to allow the elected Indian members to discuss the budget and ask related questions. Subsequently, the Government of Indian Act 1909 was passed when the British government allowed some elected representations. However, they did not
Nature
allow
of
the Indian
Indian
citizens to
society.
vote or to
India is one
participate
of
in
the
the
most
process of decision making. As the colonial government did not allow the people of our country to make decisions, therefore, after taking part in the freedom movements on a large scale, the citizens became aware of this fact that in independent India, they would be able to participate in decision making. Once the country became independent, the government tried to remain sensitive to the demands of the people. The dreams of a common Indian citizen became true after the Indian constitution laid down the rules of universal adult franchise, where each citizen over the age of 18 got the right to vote. A democratic country takes off is the idea of consent. It means the government considers the participation, desire, and approval of people before taking any decision. What people have decided creates a democratic government and how it is going to function for the next 5 years. An individual provides his approval to a government by voting for it in the elections. Once the representative who have been elected by the people become the members of parliament, one group of such MPs come together to form a government. The parliament is made up of all the representatives who together do the job of controlling, guiding a government. Here, people by their chosen MPs control the government as well. The word parliament has been derived from the French word parler, which means to talk. Thus, the parliament is a place where the representative of the people sit together to discuss, to debate, and deliberate upon the national and international issues. Position of the parliament. The parliament consists of the president and the two houses, that is Lok Sabha and the Rajya Sabha. So first we are going to discuss about Rajya Sabha. The composition of the Rajya Sabha, we can say Rajya Sabha is the upper house of the parliament. It is also known as the Council of the States. The total strength of Rajya Sabha is limited to 250 members. 238 members are elected by the members of the state and the union territories, and the rest 12 members distinguished personalities from various fields like literature, science, art, and social service. And to be the member of Rajya Sabha, the qualification is the member should be the citizen of India. He or she must not be a bankrupt. He or she must not be less than 30 years of age. The Rajya Sabha is a permanent house. It cannot be dissolved. Each member of the Rajya Sabha is elected for a tenure of or term of 6 years. One third of its members retire after every 2 years, and the fresh elections are held for the vacant seats. The Vice President of India is the Chairman of the Rajya Sabha. A deputy chairman of the Rajya Sabha is also elected by the members who presides over the meetings in the absence of the chairman. Now coming to the Lok Sabha. The Lok Sabha is the lower house of the parliament. It is also known as the house of the people. The total strength of the Lok Sabha is limited to 552 members, whereas its present strength is 545 members. 530 members of the Lok Sabha are elected from the states. 20 members are elected from various constituencies of union territories, whereas the President of India can nominate 2 members from the Anglo-Indian community if she feels that the community has not got sufficient representation in the Lok Sabha. The tenure of the members of the Lok Sabha is fixed for a term of 5 years. It cannot be dissolved as long as the ruling party enjoys the majority in the parliament. However, it can be dissolved after the completion of the term by the president. Now, to be the member of Lok Sabha, the qualifications that are needed is a person should be the citizen of India and at least 25 years of age, and he should be mentally stable, and he must not hold any office of profit under the government of India. Now, the members of Lok Sabha are elected on the basis of universal adult franchise. Every citizen has the right to cast his or her vote. Once the elections are over, the leader of the party that wins the majority in the Lok Sabha seats are invited by the president to form the government, while other parties are called as the opposition party in the Lok Sabha. The presiding officer is elected from the newly elected members of the Lok Sabha, and he is called as the speaker. The speaker is generally of the ruling party. Deputy speaker is also elected by the Lok Sabha, who presides over the meeting of the Lok Sabha in the absence of the speaker. Article 52 of Indian Constitution states that there shall be a President of India. He or she is the head of the state. Article 53 states that the executive powers of the Union shall be vested in the President, and it will be exercised by him or her in accordance with the Constitution, either directly or through an officer subordinate to him. So, to be a President of India, the qualifications which are compulsory, which are mandatory, are he or she must be the citizen of India. Him or she must have completed age of 35 years. He or she must not hold any office of profit under the government, whether it is union, state or center. He or she must not be the member of either houses, that is Lok Sabha or Rajya Sabha. He must be registered as a voter in any parliamentary constituency. Now, according to Article 54 and 55, Indian Constitution deals with the election of the President of India. He or she is elected indirectly by the members of the Electoral College, consisting of elected members of Parliament and the state legislature. The President holds the office for 5 years. What is the role of the President? The President of India is a nominal head of the state. And who is the actual head of the state? Prime Minister. Okay. So, this is the difference. The President is the nominal head and Prime Minister is the actual head. All the government dealings are carried on in the name of the President. He or she is the Supreme Commander of Indian Defence Force. The President enjoys huge power but act in accordance with the advice of councils of ministers, which is eventually headed by the Prime Minister. Now let us discuss the functions and powers of the President. The President is an integral part of the Parliament. No bill can become a law unless the President gives his or her assent. Now, this is the legislative power. Now, what about the executive power? The President is the head of the Union Executive. Article 53 states most of the executive powers are vested in him. All the executives dealing are done in his name. Appointment of Chief Justice of India, the Judge of the Supreme Court and High Court, Governors of State, elections, Chief Election Commissioner, and other members of Election Commission, and the chiefs of the three wings of the armed forces are appointed by the president. He can transfer the chiefs of the armed force to any part of the country or can dismissed. Being the supreme commander of the armed force, he can sign the peace treaty and perform diplomatic functions. Now coming to the judicial power. Being the head of the state, the president has judicial power to grant reprieve, respite, suspension, remission and commutation of punishment with respect to the criminal facing the death sentence, offense against law made under the union in the concurrent list, and so on. Executive powers. He or she is the head of the state and whose will be the president can dissolve the parliament. All the important appointments are made by the prime ministers with the assent of the president. The president presides over the meeting of the cabinet and decides the policy of the government with the assent of his ministers. The prime minister acts as a link between the cabinet and the president. Now the last one is the emergency power. The constitution provides three kinds of emergency powers to the president. The first one is declaration of emergency due to war, declaration of emergency due to the failure of the constitutional machineries, and declaration of emergencies in the case of financial crisis. The prime minister is appointed by the president and other ministers are appointed by the president on advice of prime minister. The prime minister prepares a list of other ministers and they are formally appointed by the president. The president cannot appoint any minister against the wish of the prime minister. The number of ministers cannot exceed 15% of the strength of the Lok Sabha, that is, it cannot exceed 82 members. Now, talking about the cabinet and councils of ministers, normally the cabinet and the councils of ministers are understood to be the same body, but there is a slight difference between the two. In actual practice, there are three categories of minister: cabinet minister, ministers of state, and the deputy minister. The constitution does not prescribe any qualification for holding the office of a minister. It only says that a minister must be a member of either house of the parliament. If a non-member is made a minister, he must get a seat in either of the houses of the parliament within 6 months. Otherwise, he will cease to be a minister at an expiry of 6 months. The tenure of councils of ministers is not fixed. It remains in office as long as it enjoys the support of the majority in the house of the people. When it loses the support, it has to resign. Now, what is the principle of collective responsibility? It is like one of the important features of parliamentary government, and it means that the councils of ministers is collectively responsible to the parliament. If the house of the people passes a vote of no confidence against entire councils of minister, and in that case the entire councils of minister headed by the prime minister has to resign. The ministers swim or sink together. So the parliament, first if I say, is the legislative power. The the parliament frames laws on the subject mentioned in the union in the concurrent list. Under special circumstances, it can make laws on the state list too. Talking about the executive power, the prime minister and the councils of ministers are responsible to the parliament for their actions and the policy. The parliament has the power to remove the councils of ministers by passing the vote of no confidence. Electoral power, the elected member of both the houses of the parliament participates in the elections of the president and the vice president of India. Judicial power, it can remove the president of India from his office through impeachment. Impeachment is the process of removal of president from the office. Judges of Supreme Court and High Courts can also be removed by the members of the parliament by passing vote of no confidence. Now, constitutional power, the parliament enjoys the power to amend the constitutional provisions. And the last one, the financial powers, the parliament controls the financial resource of the country. The budget of the country is passed by the parliament and controls the expenditure of the country. Introduction of a bill in the parliament. A parliament plays a vital role, an important role in implementing new bills that can change the existing laws if accepted in both the houses. An ordinary bill introduced in any house of the parliament has to pass through the following stages. First stage is an introduction of the bill or first reading stage. It is taken by the concerned minister through a formal motion, and to introduce it, the introduction of the bill is also known as the first reading of the bill. Now, after that, comes the second reading stage. Normally, the sufficient period of time is given between the first and the second reading of the bill to enable the speaker to print as many copies of the bill as required. On the fixed day, the mover rises his or her seats and seeks permissions of the houses for the second reading of the bill. After this, the initiators move any of the following proposals. The bill may be considered immediately, it can be referred to a selective committee, or it can be referred to a joint committee of both the houses, or it can be circulated among the people of their opinion. At this stage, various aspects of the bill are discussed, suggestions regarding the improvement are given, and drawbacks of the bills are removed. Now in third reading stage, after some days, the bill is again introduced in the house. Only general discussion on the bill is done and sent to the next house for its approval. Now the next stage is in the bill goes in the upper house. In the upper house, the bill passes through all the stages as I discussed above, the same procedure. After passing through all the stages, it is sent to the president. As we know, no bill can be passed without his consent. So it is passed to the President of India for his final approval. If any of the cases, the two houses have different opinions over certain issues related to the bill or the act, the President may call a joint session for the two houses. The bill is said to be passed if the majority of the members of both the houses agree to it. Finally, after the President's signature, the bill becomes a law or an act. Now, next is money bill. A money bill such as budget cannot be introduced in the Rajya Sabha directly. It can originate only in Lok Sabha. After passing through all the stages as prescribed for an ordinary bill, the money bill sent to the Rajya Sabha. The Rajya Sabha may delay a money bill maximum by 14 days. It can also make suggestions or changes in the bill. But the Lok Sabha is not bound to accept such changes. Finally, the bill is sent to the President for the approval. Now, Lok Sabha reigns supreme. Any ordinary bill needs to be passed by both the houses of the parliament. But if there is any sort of difference in opinions of or any issue in the bill between the two houses, then the joint session is called for the final decision, as I already said. The view of the lower house is likely to prevail in such a meeting. The Lok Sabha exercise exclusive power in money matters. Once the Lok Sabha passes the budget for any money bill, the Rajya Sabha cannot reject it. It can only delay or suggest changes. The Lok Sabha controls the councils of ministers. If the majority of the Lok Sabha members approve of no confidence motion against the councils of ministers, all the ministers have to resign, as I have already explained you this. Now coming to the next topic, that is powers of the parliament. As we have already read about the powers of president, now it comes the point of powers of the parliament. Again, the legislative, executive, electoral, judicial, constitutional and financial power. Now the last topic, minimum wages act. What is meaning of wages? Wages means all type of remuneration expressible in the money term, including the HRA, but excluding value of any house, accommodation, supply of light, water, travelling allowance, PF gratuity, etc. In 1946, the Minimum Wage Act was introduced in Central Legislative Assembly. The bill came into force on March 15, 1948. Under this act, both the central and the state government agreed to fix and revise the minimum wage of the employees. It was reviewed that the minimum wages should cover the requirements of the calories, shelter, clothing, education, medical assistance, and entertainment of at least a family of 4. And the main objective of this act was to secure the welfare of the workers in competitive market by fixing the minimum rate of wages. The main intention was to apply within this act was to act to the industries in an unorganized sector and to secure their interest. What were the drawbacks of this act? One of the most disappointing features of Minimum Wages Act was the revision of the wages were rarely done and the wages were not revised for more than 20 years. But the inflation goes on rising. It has also had a clause which stated that if the wages were not revised, the existing wages and the allowance would continue. The minimum revised wages were not sufficient to maintain and improve the living standards of workers. different wages were given to workers in different sector of the same type of work. Now, it is very important to ensure that the worker can give his family some amount of comfort, security, and education. After working for 8 hours a day with no day off, many workers bringing just over a third of the average family expenditure. If the government fixed the minimum wage, but this too is rarely paid. Earnings actually cover barely a quarter of the family's expenditure needs. It is the labor committees that implemented the minimum wages act in the state said that the deficiencies in its implementations were mainly due to inadequacies of the inspectors, ignorance of the law among the employers and the laborers, light punishment provided in the law, and unwillingness of the laborers to complain or to give evidence against the employees who paid less than minimum permissible wage. So it is necessary to protect the workers from exploitation, because once an employer indulges in such practices, it is bound to encourage other employers to reduce wages and hence production cost in order to remain competitive. So read the lesson from your textbook. If any doubt, place your queries in the WhatsApp group. The answers will be given in the same. Thank you so much.